Hey, everybody. So, I'm going to go ahead and get started. Nobody came to our session today. So, I'm going to go ahead and go over this PowerPoint. We're going to talk about the criminal justice system, just kind of give an overview, do some fundamentals of criminology. So, here are the different components of a criminal justice, of our criminal justice system. We have the police, we have courts of law, and then we have corrections. So the American criminal justice system has made gradual organizational changes by increased urbanization, increases in incidences of crime, the expansion of due process, rules, and procedures. The criminal justice system has discretion at all levels, meaning there are the police. These are people who decide whether or not to make an arrest. The prosecutors, whether to reduce charges or not bring charges at all against alleged offenders. We have judges who have the discretion to set sentences within some minimum and maximum range of punishments. Correction personnel, their discretion is whether to assign offenders to specific types of facilities, award privileges, or punish disciplinary infractions. So the police work in law enforcement, the history of police, it's an English legacy. The Police Act in London, 1829, is the earliest reference to our current police system. And then early police agencies in New York in 1845, after the United States became independent. So the characteristics of a police force. Well, the role of the police is to maintain order, provide community service, enforce criminal and traffic law. When maintaining public order, the police intervene when this public order has been breached through crowd control. They can break up fights, protests, manage a traffic accident, manage the traffic after an accident. They have a peacekeeping function that allows for personal discretion in how actual or threatened breaches to public peace are managed. And they have an emphasis on creating a sense of safety and security. In providing community service, police officers devote a considerable amount of time to such things as transporting the sick to hospitals, finding lost children, giving first aid, helping stranded motorists, giving road directions, etc. For 70 to 80% of police calls are service related. These types of providing community service to the public. Another role of police officers is to enforce the criminal law. The police officer can exercise their power to sanction the breach of criminal laws by giving warnings, making arrests, issuing traffic citations, or searching for and collecting evidence of crimes. Police in crime-fighting roles have been described as gatekeepers of the criminal justice system because their discretionary power can have life-altering consequences for the citizens. Among the occupational hazards of the police is the contradiction embedded within the police to mandate to achieve maximum order within the framework of maximum legality. So how do our police officers effectively police? Through foot patrol, community-oriented policing, and problem-oriented policing. Foot patrol contributes to the improved police-community relations by virtue of personalizing the police presence in the community and to improve morale and job satisfaction among patrol officers. The police foot patrols are able to deter crime simply by being visible. Some community-oriented policing is where foot patrol is implemented, elicits citizen cooperation, public safety, order maintenance, interagency cooperation such as schools, churches, and social services, identify neighborhood problems and needs, and set a course of action for an effective response. The way police approach problem-oriented policing is through community-oriented problem-solving approach, emphasis on identifying, assessing, and addressing crime-related community issues, crackdowns involving targeting a particular problem area and reallocating resources, hotspots focusing on high crime rate locations, bars, malls, bus depots, certain neighborhoods, and stages through scanning, analysis, and response. The role of the courts is to seek the truth and obtain justice, to adjudicate and sentence. The court system consists of lower courts, superior courts, and appellate courts. We talked about this last week in the judicial branch. The prosecution and defense are adversarials. They're opponents in an adversarial system. The prosecutor represents the people and defense represents the accused. Excuse me. So here's a graphic of the criminal justice process. I didn't mean to do that. I want to draw your attention to this scale down here. The yellow that you see indicates the actions of the police process. The blue are the actions of the court process. And then the green is the corrections process. So as you can see, some are connected, but the police don't get involved with the corrections. Prosecution doesn't really get involved with the police until the alleged perpetrator is in custody. In the juvenile justice system, the clients are delinquents. These are juveniles who committed a crime. Children in need of supervision, abandoned, abused children, status offenders, truants, runaways, incorrigible, or unmanageable juveniles. So here are the outcome of 1,000 serious cases. So out of 1,000 serious crimes, 500 are unreported. Of the 500 reported to the police, 400 are unsolved. Of the 500 reported to police, 100 people are arrested. 30 of these are put on probation or dismissed. 35 are juveniles, go to court. 65 are adults considered for prosecution, and 30 of the cases are dropped. Of the 65 adults considered for prosecution, 35 cases are accepted for prosecution. 5 of those jump bail. Of the 35 cases accepted for prosecution, 30 of the cases go to court or to trial. 3 of those are acquitted. Of the 30 cases that go to trial, 23 plead guilty, 4 are found guilty. Of the 27 that are sentenced, 18 are adults that are incarcerated, 5 are juveniles that are incarcerated, 9 are placed on probation. This graphic is just here to give you an insight into the criminal justice system. So where did we come up with what we know today as law, common law? Well, it existed in the colonies as English law. It's known today as common law. So the U.S. criminal law systems include these common law crimes, statutes, which are laws, and court decisions. Here's a comparison of felony and misdemeanors. So a felony is more serious than a misdemeanor. It's punishable by death or imprisonment in a penitentiary. A misdemeanor is a less serious crime, punishable by a fine, probation, community service, or jail time, less than a year. Procedural law are laws that control the action of agencies of justice and define the rights of criminal defendants. The first 10 amendments to the Constitution are known as the Bill of Rights. The purpose is to prevent government from usurping the personal freedom of citizens or taking over the personal freedoms of citizens. The Bill of Rights applied to state actions through the use of due process, the Due Process Clause in the 14th Amendment of the Constitution. The Fourth Amendment of the Constitution says the right of the people shall to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause, supported by the oath of affirmation and particularly describing the place to be searched and the persons or things to be seized. So only when there is probable cause shall a warrant be issued. And that probable cause has to be issued supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. Nobody can just walk into your house, no police officer can just walk into your house and start searching. They have to have a warrant. The exclusionary rule is not in the Constitution. It's the product of the United States Supreme Court. This rule disallows illegally obtained evidence at trial and effectively enforces the clauses of the Fourth Amendment. So if the police get something on you illegally, it cannot be used in court. The handcuffing impact of the exclusionary rule shows that research evidence indicates that only a tiny fraction of felony cases, between 1% and 3%, are dismissed or lost because of exclusions based on Miranda or search and seizure violations. The Fifth Amendment deals with the admissibility of illegally obtained confessions and self-incrimination. You complete the Fifth and you will not be able to incriminate yourself. That'll be against the law. Miranda v. Arizona governs custodial interrogations. This also contains the Double Jeopardy Clause. Contains the due process as it applies to the federal government. Miranda v. Arizona 1966 says that you have the right to remain silent. If you decide to make a statement, the statement can and will be used against you in a court of law. You have the right to an attorney present at the time of the interrogation, or you will have an opportunity to consult with an attorney. If you cannot afford an attorney, one will be appointed for you by the state. The Sixth Amendment gives a person a right to a speedy and public trial. So, in other words, you can't be arrested and have a secret trial and then go to prison. It has to be a public trial. And if you think some of these rules from these amendments are somewhat obvious, just know that there are countries, China is one of them, Iran is another one, that does not have these types of rules. They can come in Iran and pick you up out of your house and put you in jail for and give you no due process, which is due process is telling you what you're being charged with, affording you an opportunity to speak with a lawyer, and giving you a public trial. That's how due process works. There's a process in doing what's right for you in accordance with the law. So these rights that we have here in some of the amendments, such as the Sixth Amendment, may seem obvious, but it's only because we live in the United States that we are afforded these rights. The 14th Amendment is used to hold states in similar standards as the federal government. In other words, the state of Georgia cannot ignore the Constitution and the rights that you have as a result of the Constitution. So the procedural safeguards of due process is, here's what has to happen if you get arrested. You have to be notified of what the charge is. Nobody can just pull you off the street and put you in the back of a police car. They have to tell you what you're being charged with. They have to give you a formal hearing. That means you have to go before a judge. You have the right to an attorney or some kind of legal representation. You have the right to the opportunity to respond to the charges, to confront or cross-examine witnesses. You have the freedom from self-incrimination. That's where the Fifth Amendment comes in. I plead the Fifth. Opportunity to present your own witnesses. You have the right for the decision to be based on substantial evidence and facts, not just something that they dream up or they think could happen. You have the right to a written statement of reason for the decision, and you have the right to appeal. So here are the different ideas that make up the criminal justice system. You have your crime control, deterrence, concern for the victim, justice, due process, rehabilitation, non-intervention, and restorative justice. The effects of the crime control perspective: mandatory sentences, 3 strikes and you're out, preventative detention, and abolition of parole. The effects of the due process perspective are the exclusionary rule, the right to an attorney in all stages of the process, the due process rights given to juveniles, and the granting prison inmates fundamental legal entitlements. The structure of the criminal justice system is laid out through the federal system and the state courts. Here is the criminal justice process. This is how it works. You get arrested, you're booked, initial appearance hearing, pre-trial release, preliminary hearing, an indictment, which is a formal charging. You get arraigned, an arraignment, guilty pleas, criminal trial, and then sentencing upon conviction. Here are the major actors in a judiciary case. Judicatory process, You have your public prosecutor, your defense attorney, and judges. The methods of determining the factual issues of guilt or innocence include the plea bargaining, implicit pleas or explicit pleas, and criminal trial. The felony trial, here's the process for your felony trial. You get a jury, reading grand jury indictment containing specific charges of the arraignment, the opening of arguments, the prosecutor and defense attorney, direct and cross-examination of witnesses, closing arguments, summation, first of the prosecutor and then the defense, judges charge and instruct the jury, then the jury deliberates, the jury's verdict or mistrial, and then sentencing upon conviction. There are some criticisms of the court system. Overcrowded, too many cases, can't get them all through, violates the speedy trial right that you have. Sort of like an assembly line, one after the other. Too many indictments to plead guilty. Too few jury trials. Speedy trials are unattainable. Here are some options for sentencing. You can be fined, you can get probation, you can get community service, you can pay restitution to the victims, you can get incarceration, and you can there can also be capital punishment. There's indeterminate sentences, determinate sentences, and then mandatory minimum sentences. So there are some issues surrounding the death penalty. There's a moral question. Is it right? There's a utilitarian question. Does it work? There's a fallibility question. Does it kill innocent people? There's a fairness question. Does it discriminate? What is the role of the corrections? This is like an Alcatraz. I think my color here, block here is. In the history of prisons, Pennsylvania is the first prison system. There's the Auburn system, the modern prison area, the minimum security prisons, medium security prisons, maximum security prisons, ultra maximum security prisons, and then private prisons. Some issues with incarceration is overcrowding, aging prison population, prisonization effects, prison violence, prisoner rights, and recidivism. Alternatives to incarceration include community-based corrections, probation, shock probation and split sentencing, house arrest, electronic monitoring, restitution, fines, and forfeitures. A lasting thought that I want to leave you with is this statement. The contemporary criminal justice system is monumental in size. It consists of more than 55,000 public agencies, and now costs the federal, state, and local governments nearly $150 billion for civil and criminal justice. This amounts to more than 500 for every resident in the United States. So this concludes my presentation on the criminal justice system. If you have any questions or need any additional information, please feel free to reach out. Thank you.